Today we're going to look at the scenario where the salesman has lied to you, what it means in law and what you can do about it. I'm Daniel Shen-Smith, I'm a barrister of England and Wales, and contract law is one of my specialist practice areas. If you've bought something and the salesman has made a statement of fact to you about what it is that you're buying, and that statement turns out to be false, but you were relying on that being true before entering the contract, and as a result you've suffered loss because the fact wasn't true, that's what we call a misrepresentation. The salesman has misrepresented the facts in order to induce you to enter the contract. You've relied upon it being true, you've bought the thing, and as a result you've lost money because what he said wasn't actually true. Misrepresentation, along with many other things, if proven, amount to a breach of contract. There are different types of misrepresentation that we don't need to get into in this video. They are more for the law students, and if you are a law student, please subscribe because I will go into more detail in the different categories in another video. Broadly speaking, we have three different types of misrepresentation in varying degrees of seriousness. We have innocent misrepresentation, often when someone just doesn't know that it wasn't true. We have negligent misrepresentation, where somebody should have known it was true, and fraudulent misrepresentation, where somebody knew it wasn't true, but they told you anyway. If there is found to be a misrepresentation that induced you into entering a contract, the contract becomes voidable. That means you can cancel the contract and take all parties back to the position that you were before you entered the contract. In the event that it's impossible to take you back to that position, the court can award you damages or money by way of compensation by having a misrepresentation that induced you into entering the contract. There are several things that need to be established for a misrepresentation to be proven. First of all, it must be a statement of fact, not opinion. So for example, if the salesman said to you that I think this is the best car that you will ever find, that is just what we call an opinion. It's not a statement of fact. On the other hand, if the salesman said to you, this is the fastest car that has ever been made, and that turns out to be false, but you buy it because you believe that it's the fastest car that's ever been made,
that would be a misrepresentation of fact.
Because the salesman stated as a matter of fact that this is the fastest car, but in fact it isn't the fastest car. You relied upon it being the fastest car in order to part with the money, and therefore you've lost money because it isn't the fastest car and that's what you wanted and that's what you sought to buy. And you can think about this in either of the three categories of misrepresentation that we talked about. Innocent misrepresentation, maybe he thought that it was the fastest car, but he still made a statement of fact. It may have been innocent because he just thought it was. If, for example, this was a branded dealer and they should know everything about every car that they produce, and he said this is the fastest car,
that might make that negligent misrepresentation.
Because he should have known that that wasn't true, but he made the statement of fact anyway.
And finally, with fraudulent misrepresentation, the salesman knew it wasn't true, but he said it anyway, because he knew that you would only buy it if he made you believe this fact was true.
So he deliberately told you this is the fastest car, you believed him, and you bought the car. That would be a fraudulent misrepresentation because he said it to deceive you. The dishonesty aspect of him making the statement, knowing it to be untrue, makes it a fraudulent misrepresentation. This is not to be confused with misstatement, which is where they simply misspoke, but there are still damages available for misstatement, but we'll deal with that in another video. My recommendation to you, if you're buying something, particularly if it's very expensive or very important to you, is that if the salesman has made a statement to you which is very important for you entering the contract, without which you wouldn't enter the contract, I would make a very clear note of what the salesman said, what the fact was, and why you have relied upon it to enter the contract. It's also worth bearing in mind that many contracts will have what we call an entire agreement clause within the contract. What that tends to mean is once the contract has been boiled down to paper, there'll be a term in there that says this contract, as it is written, is the entire agreement between the parties, and nothing else done or said or represented becomes part of the contract. The courts have held that the wording should be very clear so as to exclude any representations as part of the contract. But if you find yourself in the position where you are relying on something that the salesman has said, and you read through this contract and you find an entire agreement clause, you might be minded to write into this contract that you are relying on the fact that the salesman has said to you. If the company is unwilling to put this into the contract, I would pause and check that it is actually accurate as to what they've told you. Because after all, if they are making a statement of fact to you about the product that you're buying, you want that to be true. So if that's not part of the contract, then why would you buy it if you are relying on this fact being true in the first place? So if the fact is true, the company should be happy to put it as part of the contract because that's what you're relying on and that's what they've told you is true about the product. All of this is codified into law under the Misrepresentation Act 1967. If I were drafting this claim as a particulars of claim, I would start by setting out who the parties are, the fact that you entered a contract and when, any terms of the contract, and most importantly, the statement of fact made by whom, where, and when in as much detail as possible. It's then important to say that you relied on that statement, you were induced to signing the contract because of that statement, but in fact, the statement turned out to be false. And as a result of the falsehood, you have suffered loss because it isn't what you expected it to be because the statement turned out to be false. In a formal particulars of claim, I would also say that you rely on the Misrepresentation Act 1967 in order to claim damages as a result of the misrepresentation. If yours is a small claim, that is a monetary claim not more than £10,000, the court won't expect you to know how to plead this case fully and properly, but they will expect you to tell them exactly what happened and why you are claiming. And if in this summary of the case you say that you were told something, it wasn't true, and you wouldn't have bought it otherwise, the court will interpret that as a misrepresentation. And whilst there is an expectation upon you to plead your case properly, and indeed, if the other side gets a lawyer involved, they will invariably say that you haven't pleaded your case properly because you've missed out various elements. The court will still interpret your claim as one of misrepresentation, if that's the case. But my suggestion is that it is always worth seeking the assistance of a lawyer to properly draft your claim so that there is no ambiguity as to what it is that you are claiming and why. And it gives the other side less opportunity to come back and attack the way that you've written your case to the court. So the next time a salesman or even a manager makes a statement to you about something that you're buying and you are relying on that being true, write it down, who said it, where you were, when it was, and what it is that they have said that you're relying on as a point of fact. And if they give you a contract, check as to whether any of those things are excluded and ask them to include it in the contract. If they are not willing to include it in the contract, I would be concerned that they've just told you in order to induce you into the contract. As always, there must be 1,000 questions arising from this video, and this is not an alternative to legal advice, but drop your questions in the comments box below and I will come back to them in other videos, and thank you for watching.